What are letters of testamentary in New York? Handling a loved one's estate after their passing can be legally complex. In New York, an executor named in a will must obtain letters of testamentary from the surrogate's court before they can access financial accounts, settle debts, and distribute assets. Without these court-issued documents, the executor has no legal authority to act on behalf of the estate. Filing errors or disputes can cause delays, making it crucial to follow the probate process correctly. With proper legal guidance, executors can ensure compliance with all requirements and manage the estate efficiently. Legal requirements for letters of testamentary. The surrogate's court verifies two key factors before issuing letters of testamentary: the validity of the will and the eligibility of the named executor. The executor must prove they are legally designated and meet New York's legal standards. If heirs contest the will, the process can be delayed. Common disputes involve claims of undue influence or improper execution. Executors must also notify all heirs and beneficiaries, giving them the opportunity to raise objections before the court approves the petition. While an attorney cannot issue letters of testamentary, they play a key role in guiding executors through legal requirements, minimizing errors, and avoiding unnecessary delays. How to obtain letters of testamentary. The process begins with filing a probate petition in the surrogate's court of the county where the deceased resided. The executor must submit key documents, including the original will, a certified death certificate, and a list of estate assets. After paying the required court filing fee, the executor must notify all heirs and beneficiaries. If there are no disputes, the probate hearing is scheduled, and the court issues the letters of testamentary. However, if the will is contested, the process can take several months. Once issued, these letters grant the executor full legal authority to manage the estate, including accessing financial accounts, paying debts, and distributing assets according to the will. What if there is no will? If there is no valid will, the court appoints an administrator instead of an executor and issues letters of administration rather than letters of testamentary. The administrator follows New York's intestacy laws, which determine how assets are distributed among surviving family members. While both executors and administrators have similar duties, the appointment process for an administrator can be more complex, especially if multiple family members wish to serve. Legal representation can help streamline this process and avoid disputes. Need help with letters of testamentary? Obtaining letters of testamentary is essential for managing an estate, but the probate process can be complex and time-consuming. Proper legal guidance can help prevent delays and ensure the estate is handled correctly. At Schlessel Law PLLC, our Long Island estate planning attorneys assist executors and families with probate, estate administration, and legal filings. If you need help obtaining letters of testamentary or handling any aspect of estate planning, call 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501, United States today.